All right, well, we are live on YouTube now, and I will let folks in. Good evening, those of you who are joining us. This is the Renters Alliance Renter Town Hall. We've just opened the doors on the virtual town hall, and so it takes a few minutes for people to come in. But if you're looking for the Renters Alliance Renter Town Hall, you found the right place. Welcome. This is the Renters Alliance Renter Town Hall. We're just getting started, letting people in. Welcome. Just letting folks in. If you're looking for the Renter Town Hall from the Renters Alliance, you found the right place. Give us a few minutes and we'll get started. Get started in just a few minutes. Welcome, everybody. We will give the next person who joins, we'll start our show. And if nobody joins, I guess we'll end the show. Okay, there we are. All right, good evening, everyone. My name is Matt Losack. I am the co-founder and executive director of the Montgomery County Renters Alliance. For those of you who don't know us, we are the first and only regional nonprofit dedicated exclusively to renter outreach, organizing, education, did I say that, and advocacy. We are based here in Silver Spring, Maryland, but we cover all of Montgomery County. And we're also the co-founders of Renters United Maryland, a statewide coalition that advocates for renters' rights and protections in Annapolis. If you have any questions or concerns this evening that can be answered by the panelists, please put them in the chat. You can put them in the Q&A too, but sometimes we miss it. So better just to put it in the chat. We'll keep an ongoing check of those questions and concerns. We are expecting our board chair, William Roberts, to join us when he gets out of traffic, if he ever gets out of traffic. But in the meantime, let me introduce who we have with us this evening. We have Rosie McCray Moody, who's the manager of the Office of Landlord and Tenant Affairs within the Department of Housing and Community Affairs for the county. We have the vice chair of our board of directors, Chris Perry, who is also with us. And it is our distinct pleasure and honor to have with us one of our state delegates from District 19. Al, correct me if I'm wrong. Who is, it is 19, isn't it?
Close, 18.
18, all right, thank you. I'll get that straight. District 18, which is the Kensington area, who has some interesting and important legislation that he's proposing that he'd like to discuss tonight. So I'm going to turn it over to Delegate Al Carr to give us an overview and have a little discussion about this legislation to get us started. Then later in the program, we'll have some information on current legislation, current issues of landlord and tenant affairs. We'll address any code complaints that are going on. And then if we do not have anybody from Health and Human Services, I'll do my best to provide some basic information and some remarks about that. So for now, let me turn it to Delegate Al Carr. Welcome, Delegate Carr.
Right. Thank you so much, Matt. Good evening, everybody. It's so great to be with you. So thanks so much for having me. So I'm Delegate Al Carr, and I am represent District 18, which includes Kensington and also Chevy Chase, Wheaton, Garrett Park, parts of Bethesda, Silver Spring, and Rockville. So I'm going to talk with you about a piece of legislation that I've introduced, and I'd love to have your input and your thoughts and your help on it. But it is it's called MC 1-22. It's a local bill that is designed to help with broadband equity. So in Montgomery County, we are blessed with some great infrastructure for broadband internet service. We have 2 providers, even 3 providers in parts of the county. There's, of course, Comcast, Xfinity, the original cable and broadband provider. And we also have RCN in parts of the county, and then Verizon Fios in parts of the county too. So what happens though is people who live in single family homes or townhomes have a choice. They can choose between 2 or 3 of these providers for their wired broadband internet service. And if they're not happy with one of the providers, they can switch to a different provider. They can call them up and say, I'm going to leave. I'm not happy with the service. I'm not happy with the price. And then that provider might say, well, hey, we want to fix your service problems. We want to lower your price. We have this great promotion, this great deal for you. So we're going to get your monthly cost down. On the other hand, people who are renters who live in apartment buildings often are limited to a single provider because their landlord, the owner of the building, has cut a deal with that provider. And the way the deal typically works is that the only one provider is allowed in the building, so it creates a monopoly within that building. And the landlord gets revenue from that. The landlord will get typically a sum of money from the provider, and that sum of money goes up for, as the percentage of people choosing that provider goes up. And in exchange for that, that provider has exclusive rights to that building. Other providers are not allowed to come in and market the service, or stand there in a lobby and offer, say we're offering this other competing service, or offer promotions. So it's really unfair, because that means people who live in these apartment buildings are getting inferior service and inferior pricing because they are limited to a single provider. And this issue is happening in a lot of different places. Any place that has multiple providers, you see this happening, and some jurisdictions have taken steps to address it. So the San Francisco has a law against it. Oakland, California has a law to address it. Here locally, Washington, D.C. actually has put in their law some safeguards against that practice. And in Maryland, Anne Arundel County has a very good law that ensures that tenants have their choice of wired broadband internet providers who are, already have their infrastructure, their wires in the neighborhood, and they just need access to that building. So with broadband internet becoming not just a luxury, but a necessity for people to access their workplaces, their government services, their healthcare, their education. It is really imperative that we give everyone access to all the benefits and having a choice of providers so they can shop around and get the best pricing and the best service. So the approach that this bill takes, MC 1-22, it mimics the law that was passed in Anne Arundel County, Maryland, about 15 years ago, and it's been working very well for about 15 years. So in that law, every landlord, every apartment building owner with 5 or more units, they are required to get a license. And a condition of getting that license is that you must give your tenants access to all of the franchise providers in the area. So it's a way of addressing, that practice of the landlords and the providers teaming up to limit competition, limit access, and create a monopoly in those buildings. So it's as a local bill, it'll be going through the Montgomery County delegation. So I am looking to get support from my colleagues in the Maryland House of Delegates who also represent Montgomery County. There's 24 of us. So the process for a bill like this is we will have a bill hearing on Monday, December 13th at 7 p.m. It's a virtual hearing. It's open to the public. So any individual or any organization is welcome to sign up and testify. So if you like this idea of helping with broadband equity, I would sure love your support. If you would consider testifying at the public hearing, or you can simply write an email to your delegates to let them know, hey, I support MC 1-22. It's important to me that tenants, renters have the same access to wired broadband competition. And of course, there are challenges when you're trying to provide broadband in a building. Some buildings are older than others, and there are sometimes challenges with the wiring or the conduits or the space in the building. And while we can't address every problem, we definitely want with this bill to address any sort of artificial barriers where the landlord is just, through an agreement, limiting this competition. And the interesting thing is that apartment buildings are actually more valuable when if a landlord were to allow competition, allow multiple providers, give the tenants that the choice, it actually makes that apartment more valuable, and they can probably get a slight premium on their rent. So even though they don't know it, sometimes I think it's in their interest to do it, but I think they're really wedded to this practice that they've been doing for a number of years. In any case, you can get more information about the Montgomery County delegation and about the public hearing that's coming up on the Montgomery County delegation's website. It is montgomerycountydelegation.com that has a list of all the bills. This is just one of the bills that we'll be considering. So you can see the list of all the bills and information about the public hearing and how to sign up either on Monday the 13th at 7 p.m. virtual. And then there's a second public hearing for a set of other bills that'll take place on the 15th. So that's montgomerycountydelegation.com. Thank you, Matt, for putting that in the chat. I'll also put my contact information in the chat as well. And so please feel free to reach out to me. Email me if you are interested in this issue, or if you have a question, or if you just want to help give us some data to say, hey, I live in such and such a building, and yeah, we can only choose Comcast, and we love to be able to access RCN and Verizon in addition to that. So now this bill is going to be vigorously opposed by the Comcast, they're going to hate it. They're the biggest beneficiary of this practice. So they're going to, launch a small army of lobbyists to try to kill the bill.
You must be doing something right.
And also the landlord industry, they benefit from it financially, so they're going to fight it as well. And I can really use your help. I think working together, we can prevail and right a wrong here and make Montgomery County really a leader in providing broadband equity. So I would sure love your support on it, and happy to answer any questions.
Well, I can say on behalf of the board of directors, I've already sampled them. Our board of directors is fully in support of this, and the Renters Alliance will testify in favor of it. I can tell you personally, I pay over $200 a month in cable connection. I've got a package, but I can go nowhere else. I can compare no other prices. I've tried to bring it down, and I see it go up every year, and there is nothing I can do. I have literally spoken to Comcast people over the phone who laugh at my predicament because they know that there's nowhere I can go and that I am trapped by the monopoly that they have. And so it is really, connectivity, digital connectivity, television, telephone, cable, and internet is becoming a very much a central issue in American life in order to enfranchise people in their community. This is the modern equivalent of rural electrification. And so, it is very important. And as you mentioned, Delegate Carr, about the, what do you call it, the digital equity or cable equity? I forgot what the term you used.
I'm calling it broadband equity.
Broadband equity. But it is. We have a whole bunch of people who can't afford this, who should be able to get access to it. And obviously, the American way is through competition. So, that's a great thing. And from whence you speak. You have you went to Rochester Institute of Technology or University of Rochester? Which was it?
University of Rochester.
Which is kind of the MIT of electrical engineering in New York. And that's your degree, isn't it?
Absolutely.
So, you know something about this. And so we're very grateful for you putting this forward. Chris Perry, who also has got a background in computers and so on. Did you want to add anything?
Yeah, I sure do. There are countries all over the world, Korea, Germany, the UK have much better broadband penetration into people's homes, more alternatives. And as a result, they have technology initiatives for young people that we don't. And we're going to lose our competitive edge if we don't start correcting the problem with broadband availability and access.
Right on. Also, for everybody, not only will we be supporting it, but we will take the information that Delegate Carr has provided us, including taking his information and putting it in our newsletter, providing specific information about how to sign up to give testimony, and links to that in upcoming newsletters. If you're on this webinar this evening for our Intertown Halls, your email will automatically go into our database for our next newsletter if you don't receive it already. So you will get that information if you want to wait for it. I mean, you can always, as the delegate says, go look it up yourself at MontgomeryCountyDelegation.com. So anything else, Delegate Carr?
Yeah, well, actually, President Biden actually agrees with this issue too. President Biden issued a executive order in July where he outlined a number of different areas where our economy needs to benefit from more competition. And this was one of a number of bullet points in that executive order. So, it's been recognized at the very highest levels that this is a problem. And, we hope it gets solved at the national level someday, but there's no reason that we can't work to close the digital divide right here in Montgomery County.
one of the reasons why we have such a challenge with the COVID rent relief program reaching high eviction communities is because of this broadband equity issue. And so, this is just one step, and it also, raises the larger conversation about that equity issue on a specific thing that matters to everybody. So it's a very good piece of legislation. There are other issues about apartment owner collusion with certain industries that benefits the apartment owner and doesn't benefit renters. So this is an ongoing conversation, but I think that this particular piece of legislation will benefit renters immensely. And so we thank you for it. And we will keep our community, which is, as you know, nearly 40% of residents in Montgomery County rent their homes. So we will keep them informed as best we can through our newsletter and other communications. And we would welcome you back if there are any updates on the legislation or any other legislation that you might have to advance renters' rights.
Thank you so much.
All right, thank you very much. Rosie, not sure where you went, but you're up next. We're going to talk a little, there she is, heard her name. So what is going on in the Office of Landlord and Tenant Affairs? What are the updates on legislation? What are the reminders on everything from window guards to the rent stabilization law that's in place? Please give us an update, Rosie.
Okay. I was just trying to turn my phone off. Hello, everybody. Landlord tenant. The regulations for the window guard addendum have been passed. So that goes into effect January 1st. So everybody who lives in a multifamily building above the ground level, who has a child under 11 years of age, must have a window guard at all openable windows. And anybody who wants one should have a window guard at all openable windows. Some landlords are telling people that the law requires that they put window guards at every window, whether you want one or not. That's not true. However, if the property decides that they want to just go ahead and put them everywhere, as opposed to trying to figure out who wants one or putting one in for you and then taking it back out, they can do that. But the law doesn't require that they do it. But if it's the decision of the property to put them in every window, they do have the right to do that. The criminal background addendum, if you apply for any property in Montgomery County, there should be a criminal background addendum that you have to fill out, which gives you your rights under the law, because there are certain things that the landlord cannot ask you about your criminal background or hold against you. And he has to tell you that before you fill out the application. So he can run a criminal background check, but he can't ask you certain questions, and there's certain information he just can't hold against you. This is actually a human rights law, but under Chapter 29, we have to inform him that he has to give you that addendum. It is on our website. It's on the landlord tenant website under publications. And there's a whole list of leases and lease addendums, and it's there. So if you're applying for an apartment and you have that as an issue, you should pull it up. What else is going into effect? I think that's it. Want to remind people that if they get a notice of summary ejectment, a notice of intent to file for summary ejectment, that is only a warning. It is not a notice to vacate. It is not an eviction notice. It's just a warning that if you do not pay your rent within 10 days, they can then sue you, that they intend to sue you for failure to pay rent. So I think it's kind of calmed down a little bit, but I just want to remind people, it's just a warning. It looks intimidating, but it's just a warning. We finally finished the landlord tenant handbook updates, and hopefully we'll get them online by Friday, because they exist. They're sitting on my desk. It's got a lot of new information in there and reminders. And let's see, what else?
Rent stabilization.
Oh yeah, that one. Okay, they passed the law that through May 16th, 2022, the landlord cannot raise rents above the voluntary rent guideline, which is currently 1.4%. But in February, it'll be adjusted again, because it's adjusted every February. So whatever it comes to be on February, at the beginning of February, when the county executive issues it, then they can't raise it above that until May 16th, 2022.
So
And
if
after
you've
that,
received a renewal notice that has a rent increase above 1.4%, you should let us know. You should let the Office of Landlord and Tenant Affairs know. It may be more of a, not only a problem for yourself, but a problem community-wide. If you're a property manager or your landlord is issuing renewal notices that have incorrect information. And when they do that, that renewal notice, and Rosie will correct me, that renewal notice is defective, meaning that they have to start from, they have to reissue it. If there's been any increase that was illegal or defective in that renewal notice, they have to credit you forward retroactive to the time they issued the defective renewal notice and reissue a proper renewal notice that is 90 days prospective. So pay attention to that. Let us know. This law was enacted to benefit renters and keep you stable and keep your rents from going up too high during this pandemic, which is still going on. So take full advantage, and we're here to help you get it enforced, and so is the Office of Landlord and Tenant Affairs.
I also want to remind you that, what's I getting ready to say? Got lost. Oh, there's a form that you can fill out if you're behind in your rent, or you got behind because of COVID-19, you lost a job, or you were ill or whatever. You can fill out this form, and it will stop the landlord from charging you late fees from going all the way back to March the 20th to March 2020 through May 16th, 2022. No late fee can be charged. Now, if you've been charged a late fee and already paid it, then it's already paid. There's nothing they can do. You will not be reimbursed. However, they can't charge you any late fees prospectively or going forward if they have not been paid to date, if you fill out this form. And the landlord cannot challenge it. If you fill it out, you're saying, this is true, I have been affected by COVID, and I am below 50% of the, AMI. And there's a chart on the back. So you can look at the incomes on the back to see if you fall within the guidelines. So I didn't want to forget to tell you that. And that they're still taking people to court. So if you're called to court, go. There's usually there's an attorney on site. A lot of from Homeless Prevention, Homeless Persons Relocation Project has an attorney on duty every Wednesday. And the court has the help center. So there are attorneys there. They can't represent you in court, but they can give you advice. And
If
you
you've
can
got a
always call
summons to go
legal
to
aid.
court, sorry,
So
Rosie,
go.
to interrupt. If you have a summons to go to court, go to court. Unless you have something in writing from the landlord that says it has been dismissed, or from the landlord's attorney saying it has been dismissed. And even then, I'd want to make sure with the court, by calling the court, that it is dismissed. In fact, you should go to court, because you automatically lose if you don't show up, no matter how good a case you have.
Yeah. And if you have not applied for rental assistance supply, they still have money. Okay. I think that's all for us.
All right. And since you're speaking for the department today, is there any news for renters about what's going on with code enforcement? Are they back in the field? And
Code enforcement is active. They are doing inspections. They're doing inspections. If you call in and you have a complaint, they'll come out and inspect your unit, and they're doing the inspections of each multifamily, per their normal business, to check they check multifamilies I think it's every 2 years now.
Every 3 years, unless
3
they're on the
years.
list.
Problem, if you're on the list of trouble properties, it's every year. And so they got behind because of COVID, because they couldn't come and do the inspection. So they're working on that and they starting to catch up on that list. But they are out, they are here and they are doing inspections.
But renters should know that they will respond to individual complaints at any time.
I said
So you can file a complaint if you have a code complaint. Obviously, we always say, don't make a complaint to landlord tenant or to code if you haven't talked to the landlord first. You got to give the landlord an opportunity to fix something, or the property manager. But we all know what's reasonable and what's not. And if you've told them once, twice, or and they're just not responding to you, then your enforcement is through the Office of Landlord and Tenant Affairs for a lease dispute or a rights issue, or for maintenance or dispute, or a vermin or mold. That's code enforcement. And I'll put
Also,
both of those in the chat.
if
go ahead,
no
Rosie.
matter what, you should contact the landlord first, put it in writing. Just shoot them an email saying, my sink is leaking. I told you on November 10th it was leaking, but nobody came. So I'm doing this again on, November 20th, my sink. And then if they don't come, absolutely call code enforcement. And don't self-evict yourself. Don't have a problem and say, well, this is terrible, I'm going to leave. Don't self-evict yourself. Because if it's so bad that you feel you need to leave, you need the county to come out and look at it too and say, yeah, this is terrible. But you have to have something to fall back on, because if you self-evict yourself, the landlord will go in after you leave, fix it and say, well, it wasn't that bad, or they never told me. So don't do that. Put it in writing, take pictures, call code enforcement, so you'll have backup. So you'll have some county agency that says, yes, she has a terrible infestation of mice, or there are rats coming in, whatever. Document, and call the county.
And we know that some of these properties have chronic problems. And the only way that we can advocate that the county put resources seriously into enforcing the law at these properties is when they see a volume of complaints that create a record. We have a lot of chatter out there, but until they start becoming a formal record that policymakers can look to and say, we've got actual code violations mounting in this building from individual complaints all over the place, that helps substantiate policy decisions and executive management in our county government. So as Rosie says, put it in writing, make a formal complaint, but always do it credibly by saying, hey, look, I gave them a reasonable chance and they didn't do anything.
I also want to remind people that there is a code enforcement handbook as well as a landlord tenant handbook, and it is online, and you should use it because it gives you a lot of what the law says. It tells you what you have, your rights in terms of code enforcement. So please browse the code enforcement handbook as well as the landlord tenant handbook.
I see some of the concerns coming up in the chat about the Warwick, and we know the Warwick is one of our movie star apartment buildings for problems, but it's not the only one. The Renters Alliance is going to be putting together in the next several months a strategy of doing individual meetings again with apartment communities. We've been hamstrung a bit because of COVID as well for doing in-person meetings like we used to do in the community rooms of apartment buildings. We hope to return to that as soon as the pandemic alleviates enough for us to do it. But in the meantime, we can still invite people to Zoom meetings like this. So the Warwick will be on that agenda, and we will bring in county officials to address the aggregate problems going on over there. I know about the water, I know about the vermin, I know about the elevators, we know about the bad management and the turnover of management, but we think that this needs to be an ongoing conversation. And I say you're not alone. There are other communities around Silver Spring and around Montgomery County that need to be addressed. Rosie, a question came up with one of our renters who's been concerned about this, that a new property management company has come in and has taken away a number of the handicap parking spaces for the management's use. Is there a law or a policy in Montgomery County that requires a portion of parking spaces to be designated for handicap parking? Is there any kind of proportionate law?
There actually is, but send me an email and I promise to tell you tomorrow. I'll get it to you so you can pass it on. They do have a number. It's a ratio, but I can't quote it to you offhand because it's not housing code law. I think it's permitting. But I can check it.
Permitting, or is it human rights? Is it possibly?
I'm not sure if it's human rights or permitting. It's not us, but I can still find out tomorrow.
All right, so the short answer to the questioner is yes, there is some kind of requirement. We don't know what it is, but we will find out and get it back to you as soon as possible. Let me give a couple of remarks. I think my board chair, William Roberts, is still stuck in traffic, so let me just say a couple of things. The eviction crisis continues. We know that there's some myths about it. One is that it was supposed to be an eviction tsunami was the thing. Well, just so you understand what a tsunami is, people see a tidal wave that comes and overruns the city in one big splash. Well, actually, a tidal wave is a slow increase of tide that continues and doesn't stop. So a couple of things are happening that have made it look less dramatic in that sense. But let me explain why it is continuing. The courts were closed until April. The eviction protection orders were in place until August and September. So if you were affected by COVID and facing risk of eviction, you were protected almost all the way through September. The courts, when they reopened, had a backlog of tens of thousands of eviction filings that they had to go through. Then we also have, even though we have concerns about the speed and efficiency of these programs, but we have millions of dollars going into rent relief for people, which has also helped thousands of people avoid eviction for now. But still, there are upwards of 15,000, says the Department of Housing and Community Affairs, renters in Montgomery County who are in arrears on a monthly basis, about 100,000 plus in Maryland statewide. Those figures represent what we know. They usually don't represent, as Rosie was mentioning before, those who self-evict, those whose housing is unstable, but haven't been summoned to court or haven't been put in the government system in a way that we can count them. So we know that there's a whole larger degree of housing instability out there beyond those who are facing immediate eviction because they've been summoned to court or received a notice to vacate from their landlords, some way that we can track that statistic. So, and we are seeing an uptick in the filings in the court for eviction. And as the court gets its sea legs back and is in full operation, and if the rent relief does not get to tenants fast enough, or if they don't qualify for rent relief because their financial situation did not meet the eligibility requirements for the COVID rent relief program, which are that you are lost revenue because of something to do with COVID, you lost your job because of COVID, you got sick because of COVID, or the other eligibility requirements of living in the county long enough, having an income that is below, I believe, 50% of area median income. This stuff is all on the website. I'll put the link in the chat. These are eligibility requirements. If you don't meet those, and we, by the way, the Renters Alliance thinks that if you're facing eviction having anything to do with COVID, you should be entitled to rent relief. We all pay taxes, and losing your home, whether you're making $150,000 a year and lost your job, or losing your home because you're making $25,000 a year and you lost your job, either way, losing your home is a bad thing. There's a reason why the Centers for Disease Control got involved in the eviction crisis and eviction protection orders, because unstable housing leads to virus spread. So this is all within the context of the pandemic. We still have a pandemic ongoing. We still have threats. Omicron is the newest thing. We're trying to get control of it. But when people have to move in with family, with relatives, couch surf, or go to homeless shelters, they increase the potential that virus could spread. So that's one issue. The other is we should all know that evictions are more than just a humanitarian disaster for people. Obviously, moving is terrible, it's difficult, but if you have children in the schools, it's going to affect their academic performance. If you're a senior citizen and you have roots in the community, or just a family with roots in the community, you're tearing those roots out and you're injuring that family's ability to their health and their ability to prosper. And you're also injuring our wider community's interest in those families' investment in our community, socially, politically, and financially. So it has a much wider ring of damage than just the damage done to an individual who is forced out of his or her home or a family's home. And who pays that price? Not just the renter, all of us do. So it has a much larger cost than that. So, this eviction crisis is ongoing. It is a concern to all of us. And we are working very hard to urge the Health and Human Services Department to consider greater efficiencies in their operation to move funds out as fast as possible. I should say that our Health and Human Services staff operation is a little bit better than some of the other regions in Maryland, but the Renters Alliance deals with renters who are desperate, and obviously we think it can move even faster. So that's where we will advocate. We also believe that they should be here tonight. And so that's an ongoing conversation that we think that that operation is so important to so many people who have real questions that those officials should be present. And that they're not here tonight is a concern for us. And we are dealing with the county on that issue, and we'll get back to you. But this is a very important program for our renters in Montgomery County, who represent nearly 40% of county residents. We are also expecting that the program will have another tranche of money coming in. I've read recently, I think it's a little over $35 million coming. We don't know what the rules are for that next wave. So questions are coming up that we wish the county officials would be able to answer. For example, if I got some money in the first program, do I have to reapply, or will they automatically credit it backwards? Do I need, if when I reapply, will the eligibility requirements be the same? Will the amount of money that's available to me be the same? So, some obviously fundamental questions about the program rules and about the eligibility, about the speed of operations. These are questions that we have for this program. However, let me say this. If you're in need of eviction protection money, you're in arrears, you're facing eviction because you're in arrears, there's two programs you need to know about. First, the COVID rent relief program, and I'll put that link in the chat. The COVID rent relief program is for anyone who is affected by COVID and has lived in the county for a year and meets a certain income eligibility requirement. I'll put that information in the chat. You apply immediately and get in that waiting list. If you've already applied and when you haven't heard for months, but now when you originally applied, you just know you were in arrears, then you received a notice from the landlord said you better pay up or else, and then all of a sudden you receive a summons from the court. You need to keep HHS in the loop on your status. HHS has stated that if you are closer to crisis, which is unfortunate that the process works this way, but if you're closer to crisis, they will prioritize you. So if you've received a court summons, that's more dangerous. You're getting closer to eviction. And God forbid you receive what's called a red and white, which is a sheriff's notice on your door that says, we're coming to evict you. So if any of that is happening, you need to email HHS at HSS, I'm sorry for the confusion, but that was their email. I'm putting it in the chat, at Montgomery County MD.gov, HSS at Montgomery County MD.gov, and keep them updated. If you know your application number, put that next to it. Say, hey, look, this is who I am. Here's my application number. I received a court summons. I went to court and there was a judgment against me. I went to court, there was a judgment against me. My landlord has filed for a writ of restitution, and now I've got a sheriff's notice on my door. Please help. Let them know that. For those who don't qualify for the COVID rent relief program, there is still funds available in Montgomery County to help you. Some of it, it's not as extensive as the rent relief program, which can offer up to $12,000 in rent arrears for rent you owe, and even some prospective money for rent that you're going to owe. But there is money to prevent evictions. There's money to help you if, God forbid, you have to put your belongings in storage. There's temporary housing available that can be arranged for you to help bridge the gap between losing one home and hopefully finding another. Rosie, do you want to address any of that renter assistance programming?
If you've applied for rental assistance, please, if you get a call, and even if you don't answer the phone, because some people get passed over just because when they get to you, they'll call you. And sometimes people don't answer, and they can't sit and just keep calling you and calling you and calling you. So answer. If you get a call, answer it. Or if you get an email, make sure you respond, because a lot of people lose their place simply because they didn't answer when HHS calls. So please answer your calls. Please keep in touch. I know it's frustrating, but they're doing the best they can. Please keep in touch. Just be persistent and keep in touch.
On the issue of other funds.
And there are other funds. If you don't qualify for COVID, there's a rent stabilization program, and they can help you. They can't give you $12,000, but if you don't owe that fantastic amount of money, they can help you. And if they can't help you pay your back monies, they may be able to help you, as you said, with a security deposit or first month's rent, or they can put your things in storage or something, but they can help. Or if you just need help with, like, they're getting ready to cut off your electricity or your water, they can help you with that. So there is help. There's help available. There may not be all the help you want, but there is help available.
Right, and you won't get it if you don't reach out for it. If you're confused by it, the Renters Alliance is here to help guide you. We can give you advice. One other thing, because we know these programs can sometimes be complicated. If you received a notice from the HHS about the COVID rent relief program that says you're not qualified, or that your application has been closed, you need to know why. We expect that program will provide you with information that says your application has been declined for the following reasons. If you disagree with that decision, then you need to say, look, I'd like to appeal this decision and have someone review it. The other thing is as Rosie was pointing out a minute ago, sometimes they reach out to people and they close your application because they didn't hear back from you within a certain period of time. But that doesn't mean that you are declined. It doesn't mean that you're rejected. It just means they're going to set aside your application and work on others that they can get in touch with until they hear from you. And one of the problems we've had with the program is that renters don't know that. So if you say, hey, look, I applied, I was in the hospital, I was away or whatever, you called me, I didn't get back to you fast enough, and I received a letter that says my application is closed, well, understand that you can pick up the phone and call 311 or send an email to hhss@montgomerycountymd.gov and say, hey, look, I still need these funds. Please contact me, or here's the information that you requested. Please reactivate my application and let's continue with the processing. You have to be on, like any bureaucracy, you have to be on top of this in order to get it to work for you. And we can help. We have a lot of familiarity with this. It does require that I take 2 aspirin and a glass of scotch to call, but I am good at it. So are some of the people that we work with and some of our volunteers. So use us to help you. If you have questions or concerns, contact us at info@rentersalliance.org. I'll put that in the chat also. Any other questions from our folks? Let's see. What do you do if your landlord sends a non-renewal lease and you owe nothing?
In Montgomery County, the landlord does not have to have a reason to ask you to leave. You can file a complaint and we'll call the landlord and ask him what the problem is and see if he's willing to work with you. But we really can't make him take it back unless you can prove it was done in retaliation for something. He has the right to tell you he doesn't want to renew your lease. And a lot of landlords are getting around failure to pay rents by filing tenant holding over. They give you the notice, and if you don't leave, they file tenant holding over. And honestly, it's not a lot of defense for that. If they ask you to leave, you have to go.
It's actually not just Montgomery County, it's statewide.
Yeah.
There's no defense in Maryland against non-renewal of the lease and eviction for tenant holding over. That is staying beyond the end of the term of the lease. The Renters Alliance has a very strong position on this. We support just cause eviction law, which exists in Washington, D.C., in New York, in Seattle, in San Francisco, and other progressive places that have had long standing renter communities and have thought about this stuff for a long time. But just cause eviction law says that in order to evict someone for any reason, including not renewing their lease, the landlord must provide a justifiable reason to do so. Otherwise, the lease should automatically renew with an appropriate, we would say, reasonable rent increase, but otherwise not changing the provisions of the lease unless it's mutually agreed to do so. But in Maryland, that does not have to happen. As long as they give you 60 days notice, then they can proceed to evict you for tenant holding over if you stay a day over the end of your lease. And in court, the only thing that the judge will ask is whether or not you received proper notice. And if you did, you can say it's for retaliatory reasons, for discrimination, for something unfair, but unless you have proof of that, there's no defense. And it's very difficult to impossible to prove otherwise. So we think it's a terrible injustice, but right now renters are prone to it.
Also, if you want to plead retaliation, you cannot owe money. If you owe money, retaliation is not a defense.
Okay, another question comes in. Do apartment residents have any legal standing to refuse keyless smart locks? The locks require putting in a code on a digital keypad or remote access to enter your apartment.
No. I'm sorry, no. If that's what the landlord decides he wants to do, no.
Well, I would imagine that it's interesting because, first of all, I'm not sure how one would have gotten into the apartment complex in the first place. So if you had a key to get in the first place, and then the apartment, the landlord says, we're locking the door and setting up this electronic thing. First of all, I'm not sure what the problem would be. I mean, okay, so I do, as long as they're not charging me for the key fob. That would be something I'd be concerned about if they say, now we're going to change over to the special lock and we're going to charge you $50.
They can't change to a key fob and then charge you because they gave you a fob. If you lose the fob, they can charge you to replace it.
Right.
But if they just change the mechanism, they can't charge you.
Right. So, something to think about. I do think that a similar question has come up, though, in paying rent. Can a landlord require that you pay by credit card or ACH transfer, electronic payment, and refuse check or cash payment?
They can refuse, I think, cash, because a lot of landlords don't like trying to keep money in the office. It's not safe, and people tend to, sometimes the staff absconds with it. And so they don't like to take cash. But that's a legal question. We've been working on that because we have a difference of, I feel like if he wants to do it that way, you need to know that up front. You need to know from the beginning. So if you've been paying cash all the time, with a check, he should accept your check until your lease renews. But then once the lease renews, if he says this is how you pay, I don't think we can stop him from doing that. But I do have an issue with them charging you a fee for it, though. But we have to work with the county attorney on whether or not that's legal either.
Yeah, we would have a problem with both of those things. Forcing you to do something and then charging you to do it is really asking for a fight. Right. So another question, somebody's concerned about waiting for months for their rent relief. Please make sure that if you have applied for the COVID rent relief program, you should have received an email that confirmed that your application was accepted. You should have a application number. You should be able to go into the website and check the status. The status unfortunately doesn't tell you much, but at least it tells you're in the system. The status will say either not yet assigned to a caseworker or assigned to a caseworker. If it's been assigned to a caseworker, that caseworker should follow up with you fairly shortly. The length of time that it's taking is usually between the initial application and being assigned to a caseworker. But if you don't see any of that, then you need to send an email to hss@montgomerycountymd.gov and say, give them your name and information and say, I applied on this date and I don't see my information in the system. Please do that. My understanding is that if you applied for rent relief in 2021, that you, as long as you did not exceed the $12,000 cap, if you still owe money and you only received, say, $4,000 before, you might be eligible for another $8,000. But you have to reapply. If you haven't applied since last April, you have to reapply for the latest program in order to be considered for those funds. Okay, but nobody is supposed to get more than $12,000 except under very unique circumstances that senior managers at HHS will determine. Generally speaking, it's $12,000 is the cap.
Okay.
I have a sorry, go ahead, Rosie.
No, just going to remind people, if you have any questions, any landlord tenant questions, call 311 or shoot us an email to ulta.intake@montgomerycountymd.gov.
Can a property manager or landlord terminate a subsidy program? So can they say we're no longer accepting vouchers? Can they say we're no longer
They have to know because it's discrimination based on source of income.
So I would suggest, Rose, send me an email. Again, I'll put it in the chat, info@rentersalliance.org. If you've received communication from your landlord or property manager that says we are no longer accepting vouchers or we're no longer accepting people who are on a subsidy program of some kind, the Renters Alliance worked very hard with the Homeless Representation Project. We were on what was called the Home Act Coalition. That coalition, which went on for 10 long years to get legislation passed called the Home Act that made it illegal to discriminate against people solely on the basis of income. It was a backdoor to all types of discrimination. It was particularly targeted at low income and minority people who were on housing vouchers. And it was just terrible vulnerability for tenants. So they passed a law that said a landlord can't say to you, if you're on Social Security, we won't take you. If you're receiving, if your way you pay your rent is from a Section 8 voucher, we won't take you. That is now illegal. So if that's happened to you, let us know. And certainly call 311, as Rosie says, and ask for the Office of Landlord and Tenant Affairs and file a complaint. The Renters Alliance likes to know because we're always advocating for policy changes and to help landlord tenant and others enforce the law when we see a systemic problem. Because oftentimes in a building, when we see a renewal notice that is defective, or somebody's getting an increase over what they're allowed, or they're sending out renewal notices that don't give you your rights as they're required to, it's usually not just one renewal notice. It's usually the whole building. And oftentimes because the property manager doesn't know the law, or there's a new property management company there, or they're just trying to take advantage of people. So we like to know about that too. So you have Rosie McCray Moody from the landlord tenant office here, and you have me, and you have my vice chair, Chris Perry. We are paying attention to these issues, so let us know. So any other remarks, Rosie?
No, I think we've covered everything.
All right. Any other questions from the audience? Let me go to the Q&A. Well, I told you guys to put it in the chat, but okay, you went in the Q&A anyway. Yesterday, I was reminded of a massive unaccompanied youth, both in Montgomery County and in the state of Maryland. What are your housing plans for this sector of our population? Unaccompanied youth. I'm not sure what that means if they're minors. It's not something that would be in the Renters Alliance lane. It sounds more something to do with children's services. So I'm not sure how to answer that question, Thalia. I'm sorry. Rosie?
No, if it's homeless youth, you still would have to call HHS. And there are programs within that agency that may be able to assist. We don't cover that specifically, so I wouldn't know how to answer it.
Let me say something about the Ripley that's coming in. Every now and then we get complaints about the Ripley, in particular about crime in the garage and the ups and downs with the management and services there. The Ripley's on our list of a place that we would like to have a community meeting just for Ripley residents. And we would like to do so in all communities in Montgomery County. So we'll be doing it as often as we can, as fast as we can. But if there are enormous amount of complaints from the past year, I'd like to know that those complaints are in writing and given to the Office of Landlord and Tenant Affairs or Code. It is very difficult for the Renters Alliance, and we are very allergic to this, to chase rumors and chase complaints that are verbal. We want to see that these complaints were followed through on with formal complaints to management, formal complaints then escalated to landlord tenant or to code, and then let us help you see that your rights are enforced. So if you want to get me afterwards and email specifics to me at info@rentersalliance.org, we'll take a look at it. If the landlord has accepted federal funds via the county COVID relief, isn't one of the provisions that they cannot then take you to court or refuse to renew your lease? Receive 60-day notice to vacate on the 29th of March, having e-signed an affordable housing short-term lease, which I never received back as fully executed. Well, there's some specifics there. First of all, I don't sign anything without getting a copy. So, for God's sakes, try to keep a copy, print a copy, do whatever. But if you received, if you think that they're trying to evict you prior to what you're entitled to, you need to go back to HHS and tell them that. That is a violation of their rule. I believe that you're supposed to, Rosie, correct me if I'm wrong, is it 30 or 90 days?
It's 90 days.
90 days.
So it's not, they can't do it at all. It's just that they have to wait.
They have to wait for 90 days before they move to evict you. And hopefully they would not move to evict you if you're all caught up and can then pay rent. But you cannot expect the landlord not to move to evict you if they make you whole. And then after 90 days, you're again in arrears. You're going to be vulnerable in that respect. But there is a 90-day agreement. And if they violated that, you need to reach out to hss@montgomerycountymd.gov and let them know. You can copy us and we'll follow through if you don't get satisfaction. All right, outstanding housing code violations though fixed, are returning, and it seems that the non-renewal is in part retaliatory as relationship has been divisive and issues brought to their attention. Well, Latasha, you know where I am. Get in touch with us. Let me know specifically. But for everybody out there in all of these cases, I'm not a lawyer. We just play lawyers on TV, but I'm not a lawyer. We do have a basic understanding of how things work, and you should too. This is a business relationship. he said, she said will not work when things get serious. We need things in writing. You need photographs. You need evidence that shows that you did the right things and that they are violating your rights in some way. So if you went down there and you talked to them and they promised this and you didn't get that, they're not going to say that when it comes to going to court or going into a more formal scenario of complaint. So make sure that you acquire verifiable evidence that you can show as you escalate a complaint going forward. Otherwise, you're going to be very vulnerable to the landlord suddenly not remembering that conversation.
So if if you've already filed a code complaint, it got corrected and it's coming back, file a code complaint again and also file a landlord tenant complaint if you believe it's a retaliatory action. So file them both, because you have some documentation that there was a problem at one point. And if you file again, they'll come back out and look at it and verify that the problem exists again, which will strengthen your case for retaliation. So, as I said before, and as Matt has said again, document everything. Send an email, write it, put it in writing, and call the county.
Rose, you're going to have to send me more detailed information. Send it to info@rentersalliance.org. I don't know who the subsidies lady is, and I don't know who your landlord is. And so we'll have to get into that offline, but I'm happy to look into it for you. Again, make sure that, whatever communication you've got going back and forth between them is in writing. Okay, not seeing any other questions or concerns by anybody else. So in that respect, it's 8:07. We've gotten through a little bit early. I want to thank again Delegate Al Carr for his putting forward legislation that I think is going to help renters if we can get it passed. That is only for Montgomery County. It's a bill to help broadband equity, as he says, and create competition so that renters have a choice of where to get cable and telephone and internet in their apartment buildings instead of having to suffer through a monopoly in one building that the landlord profits from and that renters have to pay for. I want to thank Rosie McCray Moody, the manager of the Office of Landlord and Tenant Affairs, our partner in crime, so to speak. And my vice chair of our board, Chris Perry, who has been monitoring and is going to help us out with this legislation with Al Carr. So thanks to all of you. This webinar was recorded on YouTube. If you need to take a look and see what it is we said, you can see it again on YouTube, and you will all also receive updated information in our next newsletter. So with that, thank you and good night.
Good night.